Hello viewers, happy 2019. This is Law 254, your favorite legal show that seeks to demystify the law, give you useful tips and guidance on how you can interact with the law on a day-to-day basis, basically putting the law in your hands. My name is Wakili Kiti. I'm an advocate of the High Court. So whenever someone dies without leaving a will, it's always chaotic, it's always problematic. And in Kenya, we've experienced our fair share of these chaos. Prominent families, the Kina Kirimas, the Kina Karumes, have had conflict within their families because of property that was left by the deceased who did not leave a will. So there are two states in which someone can die. The first state is dying testate. Dying testate means you died, you left a will. That simply means that you expressed your wishes on how your property or your estate should be divided amongst your beneficiaries or dependents. And then the second form of the second state of death is dying intestate. So that means you're dying without a will, which is not a very good thing to happen. And this is what brings a lot of chaos and a lot of conflict within families. And recently we've had a family also hitting the headlines because of the same issue, and that's the family of Kijana Wamalwa. The children apparently seem to be reading from different scripts. So today we wanna interrogate who gets what in the different scenarios when the deceased has passed on. So the first scenario is when the deceased has left a spouse and children. If mzee ameenda ameacha bibi na watoto, the law has envisioned a way in which the property will be distributed. So the personal effects and the household items will go to the spouse. The personal effects simply means the items within the matrimonial house. That will go to the spouse. The spouse will also have a life interest in the net intestate estate of the deceased. What the net intestate estate means is the deceased could have liabilities. So baada ya amelipa madeni yake, what remains, the wife will have a life interest in that property. What a life interest means again is she will have some say in the property until her death. So once she dies, that life interest also extinguishes. All right? So during her life interest, what powers does the spouse have? The spouse can appoint certain properties and give them to the children. So anaweza sema ile nyumba iko Lavington, child A will have it. Ile shamba iko Rongai, child B will have it. She can appoint property to their respective children. But, and this is important, her powers to appoint are only restricted to immediate appointment. She cannot say that ile shamba ya Lavington will be given to Victor in future or when Victor gets to 18 years old. It can only be an appointment with an immediate effect. All right? And then another interesting thing is if she gets married again, then she loses all her life interest in the property of the deceased. So that's why you find so many wives are well advised never to remarry, because once they are married again, then they no longer have an interest in the property of the deceased. So after that, the wife will have the personal effects and the life interest, and then the rest of the property of the deceased will revert to the children in equal shares. That is if the deceased died leaving a wife and children. The second scenario is if the deceased died leaving a wife alone with no children. If the deceased died without leaving children, the net intestate estate will be given 20% will be given to the spouse. That will belong to her. It will no longer be part of the estate of the deceased because there are no children. So 20% automatically goes to the wife absolutely. Then number two, the wife will also have a life interest in the remainder property of the deceased. So after amechukua 20%, whatever remains, she will also have a life interest. When she remarries again, that interest extinguishes. So your property inarudi kwa the family. So since there are no children, it will go to the father. If the father is not there, the mother. If the mother is not there, the sisters and the children of the sisters, and then other family members, depending on how close they are with the deceased. That is the second scenario. If the deceased died leaving a spouse but no children. The third scenario is if the deceased died leaving no spouse but children. So if the spouse is not in the picture, then the children will divide the property of the deceased equally among themselves. And the last scenario is if the deceased was polygamous. So if there are different families involved, the families will be regarded as units. So kama family ya kwanza iko na, the first wife has 2 children, and the second wife has 4 children, the first wife will have 3 units because the wife will be added as a unit. So itakuwa 2 children with 1 wife. And then the second household, which has 4 children, the other wife will be added as a unit. So the second household would have 4 children plus 1 wife. So 5 units and 3 units. So the property of the deceased will be divided amongst all those units. So in effect, the house with the most children will have the biggest share of the deceased property. The house with less children will have less shares of the deceased property. So those are the scenarios that play out themselves, and that's how the law has envisioned the property of the deceased will be shared. So the deceased could have died leaving a will but has not made provision for his son. What happens? Baba alikufa, wewe ni mtoto wake, but haukupata mali yoyote. What do? You can approach court and seek reasonable provision. So you can invoke Section 26 of the Law of Succession Act and pursue court and tell them, hey, mimi mzee alikufa, but hakuniachia mali yote. What happens? Then the court will look into the matter, assess different factors, amongst them the reason as to why mzee hakukuachia mali. Number 2, what the nature of the property that is at hand. Number 3, the circumstances of your other dependents. You know. Number 4, maybe mzee alikuachia mali before he died. They'll assess all those factors and make reasonable provisions to you. So who is a dependent and who has as of right to be given a portion of the deceased property? Number 1, a dependent can be a wife or former wife. As long as you're a wife or a former wife and you are not remarried, you qualify to be a dependent. Number 2, if you are a child of the deceased, you qualify as of right to be a dependent. Those dependents are as of right. Then kuna wale ambao the deceased was maintaining them immediately before they departed. So if you're being maintained by the deceased immediately before he left, you can seek court for reasonable provision kama haukuwa umepatiwa mali. The last thing is the procedure of how you get letters of administration. So when a person dies, anaacha mali, not anyone can come and deal in that property. You know, that will be an offense called intermeddling. Ikiwa mtu alikufa alafu unakuja unachukua mali yake, you've not received the letters of administration, that is an offense. So in order for the family to know who has the powers to administer or manage the property of the deceased, they have to go through a process in court in order for them to be given legal documents called letters of administration. So for you to get letters of administration, you could be there, your loved one has died and you're a dependent or a beneficiary. How do you go about it? Number 1, seek the legal advice of a lawyer. All right? You'll be required to get certain documents, namely the death certificate of the deceased, letters of the chief akisema kwamba you belong to that family and he knows you, the list of the assets that the deceased has, and then a guarantor. A guarantor is somebody who simply say, wewe ukipatiwa the letters of administration, in case you mess up, then they are willing to indemnify third parties for your negligent actions. So once you get these documents, you approach a lawyer, and then they'll be in a good position to guide you through with the process. And once you are done with the process, you'll get the letter of administration, and you'll be able to administer the property of the deceased. So much for that. In case you're having any issues concerning matters to do with succession, mzee amekufa ama someone mzee wao amekufa and there is property involved, we'll be happy to help as always. So that's it for the day. Thank you.